Good afternoon. Lisa, can you hear us okay? I think we'll just go ahead and get started and assume that this is working. I'd like to start off, this is Joel Carney. I'd like to thank everybody for joining our webcast today and our seminar topic, Keeping It Real, Ethical Advice for Social Situations and Social Media. Mark Weber and I are here in Omaha, and we're excited to present on this topic today. We'd like to encourage as much interaction as possible today because I think that'll make for a more practical and better experience for everybody. And since I know that we've got over 100 people that signed up for this webcast, we hope that you'll participate and ask some questions. We're just going to check a couple things. Looks like everything is working fine, and so we'll get started. Anyway, my name is Joel Carney. I'm a lawyer here in Omaha. Been practicing about 17 years, primarily in litigation, and I'd like to, I guess, introduce, and I think a lot of people have met Mark since he's traveled the state and presented a lot of times on ethics in his 3 years as a counsel for discipline, but I'll turn the mic over to Mark now, and we'll get started with the presentation.
Thanks, Joel. Thanks, everyone, for participating. This is exciting. Actually, my first webinar, I think we've done others, live sessions where we've had people able to log in, but this is the first fully functional webinar. So with that, why don't we just start getting through the slides. I encourage questions. I think it makes it move faster for everybody. We know you want to get your credit, and I think I have presented on this on a few occasions, but not that much. So hopefully you'll find today's presentation interesting. All right, many of you got the flyer indicating what we were going to talk about. One of those was in social situations, and I think it's totally analogous with social media, of the danger of creating inadvertent lawyer-client relationships. And we go back to what our mentor Joe McQuillan used to say. We called it general terms family law, and that included neighbors, friends, etc., that wanted to rely upon us as attorneys to give them legal advice, even in areas where we really didn't practice, and they'd persist in asking questions anyway. Communication with and investigating witnesses in litigation or other matters, and the danger of communicating with a represented person. Social networking and judges. Social networking and jurors. Trial publicity, many of you are aware of some of the ethical issues that were involved in a recent fairly high-profile case here in Omaha. Preserving confidentiality, that the age-old curse of it's nice to tell stories about what we work on, but we need to be aware of the loose lips do indeed sink ships and can get you into trouble. The ever-pressing issue of advertising and solicitation for those of us that are still out trying to make a living, and other issues we'll wrap, if time permits, with how my office operates and what we see going into the future, and some of the issues that really focus on, our office focuses on with regard to discipline. So with that, why don't we jump into it?
So we just kind of wanted to start out with the flyer that kind of talked about that threw out a hypothetical. And if you've been a lawyer for any time at all, or even a law student, this starts happening immediately. You get somebody approaches you and says, "Hey, I know you're a lawyer. I have a question for you." And so this is kind of really designed to be food for thought for everybody to talk about what you have to think about before you start jumping in, and what considerations you make. So I guess generally, kind of a question I had when I read this, Mark, is, in your experience, or is this a national problem? I know that it happens all the time, but do you actually have many clients or people that perceive themselves as clients calling your office to complain about these situations?
I don't see it that much, and I honestly don't hear about it that much nationally either. But it is something that we should always keep in mind, whether it's socially, whether it be at the local tavern or at the wedding reception or over the Thanksgiving dinner table. and sorry if you get hit up with legal questions while you're trying to enjoy the holidays. But, you know, I would also add in terms of social media, I think it'd be very, very hard to believe that someone from California logging on Facebook would think that Joel Carney was their lawyer because he made an off-the-cuff remark on in some chat rooms. So I think, having said that, we want to be aware of it. You need to be thinking about it. You need to ensure, more so when the person comes into your office and has that sit-down and that statute of limitations is running within the next week, that you might get yourself over a barrel if the person is led to believe that you're willing and able to help them, and some ethical responsibilities might kick in. So moving on, this issue of creating inadvertent relationships, what does it make? What does it take to make that relationship? Well, it's pretty simple. It has to be reasonable, touching on what I just said, the California over the net example. I don't think that's necessarily reasonable, but subjective belief that the person is seeking and obtaining advice from you. And you really should be careful giving off-the-cuff social networking site advice or specific advice to people who ask questions on social networks, because you just don't want to be in that situation, have to answer, well, wait a minute, I didn't really mean what I said, or I didn't really think that I was giving legal advice, I was just trying to be friendly, or let's be honest, in certain circumstances you're proud of that degree and you want to throw advice out there. You just need to be aware of it. I think that's the key of how my office operates. We want you thinking about ethical issues, not freaking out about them or afraid that I'm going to come up with a net and catch it, because that's not what we're about. So just be wary of it, I think, when you're on that site.
One thing that pops into my head, Mark, when I read this, I mean, reasonable subjective belief, I mean, what if the person is just a wacko? I mean, do you really take this potential person as kind of like what I would think of as an eggshell, take them how you find them? What if they are just, you know, how do you avoid that, you know, even if the person is out there and is just talking and it seems like they're crazy, but if they, where's that line drawn?
Well, unfortunately, there's nothing I can do to stop that person that might be on the fringes, and believe me, I get contacted by people like that every darn day, and that's why I have a bin that's labeled miscellaneous, or the next level up would be RTI, or refusal to investigate. You can kind of see it coming a mile away now, especially after having been there for over 2 years now. We do have our frequent flyer complainants, so we give them the attention that is due them. We try to give them a voice. We try to let them know that we're hearing them out, but usually I can talk them off of the ledge and indicate that that's just not something that we would get involved in terms of discipline. So if that answers your question.
Yeah, I think it does.
All right, moving on. It's pretty simple. You know, people have contacted me and said, well, you know, social media, the increased use of technology is a big deal, and I really think it'd be cool to talk about how that changes the ethics of the playing field. And I have to chuckle because ethics hasn't changed, you know, from what we learned in kindergarten and growing up with our parents. That's remained the same. Now the vehicle involved in social media especially has changed dramatically, but just keep your eye on the ball with the rules. I would encourage everyone to, from time to time, review the rules of professional conduct, maybe make that a New Year's resolution to just run through them. I run through them every day because it's my job. But, you know, you just, like when you're talking with witnesses, and keep in mind here, folks, the arm of the Counsel for Discipline is probably larger or longer than you think, and that's not a threat. It's the reality is you as sole practitioners or you as managing partners are bound by the rules, 5.1, to ensure that everyone in your office, from your paralegals to your law clerks to your private investigators, follow the rules of professional conduct. And if they don't, then I'm going to be investigating you. So the big rule when you're talking to witnesses or having someone investigate is you cannot imply that you're disinterested. The example, again, was the private investigator in the Garcia case, that the woman talked to him frankly and was grateful that she didn't think she was going to have to be a witness because that's what this private detective led her to believe. And then in the end, she is terrified when she realizes that this investigator was not an Omaha police officer or one of his agents, but actually a private investigator for the alleged killer of 4 people. So, you know, that would be something that might be investigated. Is, wait a minute, did you mislead this person to believe that you didn't really care about the outcome when in fact you got a paycheck to, you know, help one side or the other? So just keep your eye on the ball with these rules. Now, with social media, you can obviously, in certain circumstances, to be diligent, you should view public pages of witnesses, opposing parties, etc. And you have to advise your clients, beware of what you put up there, because it will be subject to subpoena, and there's no unringing that bell, and it's sometimes pretty embarrassing stuff. And in New York, they say you could make a friend request to an unrepresented witness. I don't think you could do that in Nebraska. I think that's crossing the line. I think to be safe, don't friend anyone that might be on the other side of a case you're involved in. And then this goes without saying, I mean, a lawyer may not create a false social networking profile. Well, isn't that proof just in the phrase? Why would you do anything that's false? Why would you say anything that's false? So you can't have your law clerk say, well, reach out and friend this person. I know in real life scenario, it was a private investigator went to a tavern and sat next to a potential witness, bought a few drinks, and then pumped that person for information that was helpful to the other side. That's a no-no. So you can't violate the rules through another, and you see that Philadelphia ethics opinion basically that says exactly that, and that's how we would feel about it. You shouldn't communicate with a represented person regarding the subject matter without contacting opposing counsel. We all know that. That pretty much goes without saying, but that is Rule 4.2. And as I said earlier, don't violate the rules through another person and stand back and say you had nothing to do with it, because we see that, frankly, happen all the time in my office.
You kind of talked about being responsible for staff members. I mean, do you have to? I know we have CLE requirements. What do you encourage people to do with their staff?
Well, we've done one, and actually it was great. I'd like to see it happen more often, but we had one where it was a joint presentation at the Scott Conference Center at UNO over in Exarban Village, and it was a joint matter for lawyers and for the Professional Paralegals Association, and I thought it was well received. If any of you out there attended that, I'd sure like to hear back from you. But you know, like a boss's day deal, we've toyed around with the Bar Association, throwing a joint conference for attorneys to bring their staff, and we can talk about these things. Because one of the things that's a corollary of this for your staff basically running around without proper supervision is the risk that your staff could be prosecuted for unauthorized practice of law. You can always access public pages on social networking sites, but you wouldn't want to make a friend request. But again, as I said before, you know, and you have to counsel your clients accordingly, that their accounts will be subject to subpoena. And the last thing you want to be involved in with a client, number one, I say when I go back to thinking practically as a practicing attorney with clients, especially in the personal injury area or even domestic for custody purposes, you know, social media is great, but boy, it can be a double-edged sword. That stuff is out there. You cannot advise your client, obviously, to purge that information post-litigation. It must be preserved. But you could certainly advise your clients prospectively to say, you know, why don't you just have a filter, and Joel knows the technology much better than I, that you just routinely clean your comments out every 30 days automatically, and that's part of your protocol. You can't be questioned for that later, especially if a lawsuit comes after you've been engaged in that practice. And this is simple, but it just is referenced by a San Diego ethics opinion. You can't friend requests representatives of corporations that have authority to bind the corporation. The fact that somebody asked that question I find somewhat humorous. It's the old, if it seems like it's probably wrong, it probably is. I'd adhere to that mantra. Social networking and judges, I provide some examples from other states, but keep in mind, we've got states where judges are running for their bench spot, and so they allow certain contact that probably wouldn't be allowed or appropriate here. I don't have authority over judges, as many of you know. That's through judicial qualifications. Corey Steele's office for judicial complaints. We refer a lot of complainants out to them. It's permissive in some states. I just don't think it's appropriate necessarily here unless it's purely social, unrelated to work. And this is where judges can get in trouble if they're making ex parte communications with an attorney in ongoing litigation. It's going to just taint the process, give the public at least the perception of the appearance of impropriety, even though we trust our judges to be fair. And South Carolina says not to do it. New York and Ohio permit judges to use social networking. As I say here on this slide, Nebraska would probably agree with North Carolina and say just don't do it. Same rule for mediators. I mean, sure, mediators, they want to market their skills and they reach out. The problem is the mediator, like a judge, is supposed to appear neutral. So my caution to anyone that's thinking of mediating and then using social media is, well, if Joel suggests a mediator and I Google that and determine that they're buddies on social networking, I'm probably less likely to use that mediator. And I think that just makes sense, doesn't it? Another one, just more on a humorous note, it's harder now. I mean, the days of going to the tavern after you lost a dogfight because you thought the judge missed something or you just vehemently disagreed with the judge, that's one thing. But now voicing those concerns over social media, that's just something you really want to avoid. And a really good example of that is this slide here. I don't know, Joel, do you recognize that particular judge? Anyway, but the lawyer got in trouble for calling a judge an evil, unfair witch, seemingly mentally ill, had an ugly, condescending attitude, unfit for the position. And that got that attorney in trouble down in Florida, and it probably would here. Jurors, the law is clear, pre-social media, just common sense. Don't mess with the process. Don't try to influence a judge, juror, prospective juror, witness, etc. And don't communicate ex parte during the proceedings unless you're authorized to do so by law or court order. And that's kind of humorous. I had one of the deans at the Nebraska Law College called and said, "That's in the rules. What does that mean?" And I have to confess I didn't know what it meant. And then I realized contacting a represented person is allowed in certain very limited circumstances by court order. And it was tailored under the model rules for attorneys generally out east that were seeking class action status. And so they felt hamstrung by the rule, but also in the interest of fairness would say to the judge, "Hey, I don't even know if this is a viable claim. It sounds like it might be, and it sounds like it might affect a lot of people." Then in certain extremely limited circumstances, with opposing counsel aware of it, a judge would allow limited contact by the opposing side to reach out to people who are actually represented. And that's the only exception I can find. And I can tell you this, that doesn't really happen here in Nebraska. So after discharge of a juror or the jury itself, you could contact them. Many times we do to find out what we did right or what we did wrong. And my mentor told me to stop doing it because it just drives me crazy, because juries tend to come down on issues that we think were not important or in fact irrelevant to the action, but you can't mess with a juror and try to affect the outcome. That's just forbidden. And you could, again, like you would with a witness, you could and should look at the public portions of a juror's networking site, and I'll tell you, you'll find it interesting from what they say in a juror questionnaire versus what they've posted on their Facebook page. And then you can't jump in and make a friend request, just like you could not do that with an opposing party. And just can't, again, you can't give the impression that you're disinterested when we all know that you are. You're partial for your side of the case.
Got a question, and we've got some slides kind of down the road about this, but the thing that I'm thinking about is what about, so we're kind of talking about social networking here, what about the sites, the AVO sites that, you know, we've got lawyers actively answering questions that are proposed to them by people that are a lot of times just looking for free advice. I mean, can it go that far? Obviously, when you sign up for AVO and they click the boxes saying, yeah, you're not creating an attorney-client relationship, there's some of those disclaimers that AVO puts out there. What do you think about that? I mean, can we rely on what AVO and other big box, you know, LegalZoom says?
Well, that's the big pressing issue right now nationally, is that very issue with AVO and whether it's an unlawful lawyer referral program. AVO says it's not, because the prospective client is free to go to whomever they want. AVO doesn't direct what you or any other attorney can do, as in you may not do any pro-life work if you're going to work with us, because we have a huge pro-choice stance at AVO. They don't do that. Having said that, there was a very, very strongly worded ethics opinion out of Ohio in the last several months, and if any of you are interested in it, I'll be happy to send it to you, but it's very much strong worded, said thou shalt not use AVO. Okay, now those of you out there, many of you are users and participants of AVO, do not fret. We are not taking a stance of prosecuting anyone that is currently using AVO, legal services, LegalZoom, any of those. We're really in a sit and wait, and I have the approval of the court for this, that we're going to sit and wait until this all shakes out. Personally, I think the concern about unlawful lawyer referral service is overblown. For those of you that don't know me, I was in private practice in Nebraska for over 25 years, and we just don't do things that way in Nebraska. We play by the book. We generally, for the most part, our good lawyers are well-intentioned and want to follow the rules. The key thing is we maintain our professional independence. We're not swayed by someone who's referring clients to us, or we shouldn't be. So I don't think it's as big a deal as maybe some. I know, and that's easy for me to say, there have been attorneys in Ohio that have been prosecuted for using third-party referral services. Just matters back to potential juror misconduct. If you're aware of this, you really want to report it immediately. Seeing or being aware of a client doing research. We know some people have actually posted real-time info about ongoing trials. Friending a defendant in an ongoing trial, a no-no. I actually had one juror really like this hunky firefighter, and she reached out and asked him on a date during a trial. That's a no-no. And then obviously polling friends. What do you think I should do? How much money should I give? I don't know if it's ever had to happen to you, Joel, but I think that would be bad.
That's bad.
Trial publicity, this again, we touched on it a little bit earlier. Very dangerous, and I get very strong feelings. When I first spoke of this last fall, probably about that, concerning that very same case, I had some pointed questions from the audience, because we're all staunch supporters of the law and the rule of law, and supporters of the Constitution. But I had some people in the audience concerned that that was a First Amendment violation. You had a right to speak your mind. Well, the rules change when you're in the middle of litigation, especially in a high-profile criminal case. I think the rules are pretty clear that you may not affect the outcome with prejudicial statements. Now, having said that, and that includes anything you would post on social media, and this particular attorney was posting matters on her Facebook page, but also making statements in live press conferences. The jury's still out on what's going to happen there. It's a matter under investigation. I know certainly it is in Illinois, but you know, you can only go so far, and we'll touch about a few of these things. Inflammatory information, you can give very limited information, but sometimes the line gets blurred, and it's suffice to say that if you feel the line's been crossed, you may take steps to try to, you know, diffuse the inflammatory nature of it, even if it's something so innocuous as to say, well, I know that's what the prosecutor said. I think we just need to sit back and wait. I don't believe that's what the evidence will show, and I would just encourage everyone to sit back and wait till the end of the trial and let the process go through. So you just don't want to get in a situation where you're trying your case in the court of public opinion, and that includes live with the media or certainly making statements on social media.
It seems like this stuff is all changing so fast. You brought up Facebook, you haven't said Twitter, the Snapchats, and I assume all these rules are going to apply across all platforms, and again, it kind of goes back to your initial statement about the rules don't change no matter the forum.
Yeah, and I don't see these rules changing. We'll get to that exception when we get to advertising, because I think that's a real exciting area, at least it would have been to me if I were still out there in private practice, you know, trying to pound the pavement to get clients on board. As I said, with the prior admonition about being careful not to sway the outcome, if you feel that someone's crossed the line, it's provided right in Rule 3.6b. A lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from substantial undue prejudicial effect of recent publicity, not initiated by you. I mean, you can't throw something out there and then use that as the excuse to say more. This is a big deal on confidentiality, and it's something that the National Organization of Bar Counsel has addressed in 2 of the last 3 conferences I've attended. Be careful, and this use of AVO is a good example. And you just got to keep your eye on the ball about confidentiality. And here's the extreme example. Everybody knows that your high-profile client was caught doing something he shouldn't have been doing and lost his position or just really got crucified in the press. Everybody knew about it. If you get into a crosswise position with that client and that client says bad stuff about you on social media, avoid at all costs the desire to come back and fire all of your cannons at once, because even if the whole world knew this information, even if it's out there, if it came from you, you're going to be in trouble. You're at least going to have to explain yourself, and it may not end up well because you're violating confidences and secrets. I don't care if they heard it from somebody else. So the exceptions are clearly within 1.6, and it's those 4 you see, you know, the obvious one, commit a crime or reasonably certain death or substantial bodily harm. You guys might be amazed at how many of those calls I get every year. There are 2 exceptions that I think you need to keep in mind that come in, and this is the one, the crime exception, but the other that's equally important that people agonize over, and they really shouldn't, is in the area of diminished capacity. You can tread over the line of confidentiality. We tried to take baby steps. Could you contact the spouse? Could you contact a loved one, a neighbor, family member? If you can't, then you need probably to go to the next level, a healthcare professional. Go to the next level. You might have to notify your judge or the Office of Public Guardian, any one of those, but you can allow in limited circumstances yourself to reveal confidential, privileged information to help your client in the situations that I've just noted. both the crime exception and the diminished capacity exception. If you have any questions about that at all, make sure you call my office.
Do you like calls, or do you like an email, or how do you prefer to be contacted?
Well, I try to be available as much as I can. Obviously, things like this, I'm out speaking quite a bit. I think 100 some times now in 50 some months, and that's important to me, and I think it's important to our attorneys, and I think it's important to the public. But we are now, and maybe the attorneys won't like this, but we are now accepting email complaints, and oftentimes I may take calls when I'm commuting from Omaha to Lincoln and back to say, that's a really good question, shoot me an email, and it's a little more clear and concise for me when you put your questions in email. But yes, you could and should contact me whenever you have a question. We serve you as well as the public, and actually it's enjoyable for me because it's like a puzzle. I like to solve it. I like to help you solve your problems. And I have to say, I think I'm pretty good at it. Having been in private practice, having been on the advisory committee and chair of that committee for 5 of the 10 years I served on it, I can usually get an answer to a question for you pretty quickly. And the other reason I say this is, you know, take advantage of it while you can. Iowa just passed a rule forbidding their disciplinary office from taking calls. The American Bar Association, in their audit of my office, frowns on the fact that we're so accessible. Why, you may ask? Well, in the more litigious states, they see it being used more and more as a shield or a defense to a prosecution. I don't see it that way. The chief asked me even, what do you think about that proposal? I said, I think it's a dumb idea here in Nebraska, because we're out to help people. We're out to help you avoid ethical pitfalls when you don't really know the answer. And I'm not saying I know the answer either. But I promise you this, I'll try to get the answer for you as quickly as I can. And if it's something really formal and complex, obviously I'm going to refer you out to the advisory committee. They do great work, and you guys see those ethics advisory opinions in the Nebraska Lawyer that the NSBA is so nice to put out there. And also, mentioning the NSBA, that we work with them all the time to get resources out there for you, whether you have questions of ethics issues that might be pertinent for a seminar. We're happy to do it. We work together all the time. So take advantage of those resources, folks. More on confidentiality, public defender blogging about cases. You know, the criminal defense, I had done quite a bit of that in my career. Boy, it sure makes for good stories, but you really do need to be careful about sharing privileged, confidential information to the general public just because you're having fun talking about it. This is what we talked on earlier. Joel and I were interested in this because it's really a hot topic for you lawyers out there in private practice, wanting to take advantage of social media advertising. And I had to laugh. I got 2 back-to-back requests as chair of the advisory committee. The first one was, may I use Groupon advertising? You see that in the site there, 1203. And then the very next one, and I don't know why I have them in reverse order, but oh well, came in like a week later. I want to use testimonials like you see down in other jurisdictions that say, my lawyer is the best ever. Aside from having my ethics hat on, I'd take that off right now and say, can you do it? Sure, both those opinions say you can, but going back to my practical private practice thought, I think it's a bad idea, especially the Groupon ads. I mean, you're going to do a divorce for $500 because of a coupon, and then guess what? It's going to be more complex, and then you're just going to be in a box about delivering on a promise that you may have made. You could get stuck. Testimonials, there's so many disclaimers with testimonials. You run the risk of, I suppose, being criticized if nothing else, but you have to say, yeah, my lawyer was great. Well, it was a very unique case. We got to settle quickly. Facts of each case are different. By the time you get done with the disclaimers, I don't know if the testimonial was that great. Again, practically speaking, I attended a mass tort litigation conference in Las Vegas within a year before I hung up my hat and did this, and there was really effective means to get your word out there, including YouTube videos, etc., on issues that were pertinent about something that may or may not have happened. You see what goes on with Syngenta, etc. But personal injury attorneys that have a satisfied client tell their experience and not have the lawyer speak at all goes a long way to show the public how much that person loved their lawyer.
That Groupon for $500 divorce must be no kids, and no money.
Maybe not even a marriage, huh,
Yeah,
Joel?
exactly.
Okay, this is a hot issue. Direct contact is forbidden. The high-pressure tactics, show up at the front door or in the ER or contact the best friend and say, I need an introduction. That is frowned upon, and that doesn't change with social media or with in-person solicitations. But this advertising rule is something that is really taking hold here, and you'll see this last bullet point for me to comment that there is a proposed rule that's going to go before the ABA House, I believe, at the mid-year meeting in February, where Joel gets to go and hang out in Miami. And I should confess, though, that the NOBC also holds their annual or their mid-year meeting and their annual meeting, for that matter, in conjunction with the ABA, so there is some crossover there. But basically, in a nutshell, and it's exciting, and I think appropriate, that given social media, given computer technology, really going to just take the advertising rule and throw it away. It's hard to enforce. The only thing that will remain if this passes is a prohibition on direct contact. Even like chat rooms, the comment to the proposed rule said, look, a chat room is not really a room and you don't really chat. You can hover in and you can leave whenever you want. It's not a high-pressure deal like a knock on the door or a telephone call. So as long as you're not making those direct contact, high-pressure type meetings, you're going to be able to do basically whatever you want to do in advertising. It's why you note TV and radio does not say it's an ad, because everybody knows it's an ad. Everybody knows it's a commercial, and that's what you have a channel changer for. You can get away from it. And that's really, the ABA has finally gotten around to realizing what really goes on in those situations and is going to allow you to market yourself pretty much like never before without any fear of reprisal from my office or a competing firm, etc. One of the things, you don't have to submit ads. I'm happy to review them. I think I'll show an example of one where they chose not to have me review. I don't know, Joel, is that next? Yeah. Sorry if you're the attorney that posted this, but he was good-humored about it when I asked him what he was thinking. And there was no prosecution in this. There were a lot of complaints. If you've been suspended for 5 years, you can drive within, I think it said, 80 days guaranteed, and you'll see the big asterisk there. And I asked that attorney, what did that mean? And he said, oh, it was a full refund. I mean, there were certain circumstances where it would not be allowed, a permit would not be granted, and he offered a full refund. The interesting anecdote here, before I even got around to investigating this, that attorney had been flooded with so many calls that he threw up his hands and ran away and took that billboard down because it almost overwhelmed him. So in that example, it's kind of a good-natured ribbing. I would suggest perhaps you would want to call my office first, and I might talk you down from just putting yourself in that situation.
All right, I'm trying to find where the question box is here. Hold on just a second.
I think what I was getting at on that as well is that you really don't have to run ads by me. I'm happy to, probably more on the line of practical advice, but we're really going to let you do what you want to do. Now, I will say on the advertising part, this is kind of a corollary that I'm getting more and more criticism from the public and from your fellow lawyers about the fact that we don't appear to be policing firm names. One that comes to mind, and if you remember that firm, I'll out you. You can call me later and tell me, is Husker Law, right? Husker Law Group. We have another one out there that was marketing themselves as the premier firm in Nebraska, and people are saying, well, how are people measuring themselves by giving themselves that designation? I don't see it as an epidemic, but I will tell you that I've seen an increase in people questioning this firm names and how firms are marketing themselves. And I say that just after saying that the ABA is really looking at loosening the restrictions on how we advertise, but I do think firm names is part of that. Are we getting questions? I can't read it.
Is a periodic email newsletter classified as direct contact?
Well, I thought that was included in one of the earlier slides on advertising, and there is an ABA, I'll see if I can, or not ABA, my clicker is not working now. I think that answers your question. Direct contact via social networking sites is prohibited in person solicitation, except, and that answers your question, contact with current and former clients, lawyers, and people with whom the lawyer has had a prior relationship, or they hear it from a friend and say, Carney's got the answer, if they call and ask you for it. But a blast, unsolicited, I don't know. I don't think it's an egregious problem, but I think, still not working, okay. I think you probably would want to contact me. I know people send out newsletters all the time. Some have purchased mailing lists, through West or wherever, for a targeted group. But if you're running it in the World Herald, I think the easy answer is if you say this is a solicitation, you're going to be fine. I hope that answers your question. But look at that advisory committee opinion. I think that would cover most any question. But if ever in doubt, you call me first. But if you don't want to call me first, just put in bold, this is an ad or this is a solicitation. And you're going to be good to go. Okay, what do we have here? Other issues. Okay, this is the matter that I talked about cleaning up social media. And, pre-litigation, to give general advice to your clients like I'm giving to you, just purge your, I don't know how to do it, Joel does because he's tech savvy, but just have it set up that comments go. It's like Snapchat, right? The photo only lasts for so long and it's gone. But it's not okay, obviously, to tell them to destroy it in anticipation of litigation. And these are a couple examples. This attorney, his wife, he was involved in a lawsuit, and he had a shirt that said he loved hot moms, and his lawyer told him to take it down. And then when they asked in discovery, we don't have a Facebook page as of the date of this response. Well, it was a big lawsuit. I forget the details, but anyway, because they did not include the offensive stuff to show that this guy was kind of not that enamored with his wife who had passed, because he liked to fool around. And the note here in the parentheses too is don't blame the omission for not having that information on your paralegal. That might come back to haunt you. But anyway, the court imposed sanctions and reduced a $6.2 million verdict down to 2.1 because of those shenanigans. So, and you know what happens there? I'm going to see this. If this happened in Nebraska, I'm going to see it. Most likely, I'm warning you, I'm going to be getting that from a judge by virtue of an order or a transcript of the hearing where the judge is pretty hot about the stuff going on, and that's when I'm going to launch an investigation. Katie Roll versus Katie Roll, a suit over trademark infringement, and they changed the profile pictures, but they maintained the offensive data that was turned over later. And so it was recoverable. Yes, it was shame on you, and it might be something I'd investigate. certainly not as directly as I might in that case where the lawyer says destroy that stuff. But in Katie Roll, they preserved it at least, even though they'd removed it. You know, might get an admonition on that one, or ask you to explain yourself. Other issues with technology, and Joel and I used to practice together. I don't know if he talked about that, but our little firm wasn't one to want to spend a lot of money on young associates, clerks, etc. So they're more than happy that guys like Joel and me would go out and buy all the latest stuff, the iPads and iPhones, and would be glad to let us upload our calendaring and email to our own devices. Well, I attended a national conference of American Bar Association on this BYOD, bring your own device, and there wasn't one thing in that hour that didn't terrify me thinking about what it was like being in private practice. I was very thankful that I am now a public servant. Anything that could possibly go wrong will, and at the worst possible moment, says the one quote. And just think about the fact that you make that decision as a young lawyer to jump firms on a late Friday night over a glass of wine, and you've made the jump on Saturday, and you've got all those emails and access to the database of the firm. You have breached confidentiality at that point. You may be in trouble as the lawyer leaving, and worse for the firms that are remain behind, you've breached confidentiality. Someone that is no longer associated with your firm has all of your clients' secrets. That is a potential disaster. The big firms, it's easier for them. Some of you are with big firms. They go so far as to say, no devices, don't want to get political here, no separate private email server. You will have one for work and one for play, and never the twain shall meet. And even with the firm devices that we're going to give you, the phone and the laptop, you may not load any app without our IT people knowing about it and approving it. And yes, it's going to cost more, but it removes the headaches of what is going to happen in our more mobile world. And you'll see from my office and nationally, we are trying to become more user-friendly in recognizing that you will not be at that firm for the rest of your days, and will allow you to move and screen to allow you to continue to practice at what may be a competing firm. That's a story for another day.
That's interesting to me, but you talk about the big firm example, but what about a small firms that don't have an in-house IT department to manage the devices? And I think that'll be an interesting question, I guess, that'll probably be evolving as we go forward.
Yeah, and on the issue of technology, there are people like me that have relied on people like Joel to get me in the right direction and help me remember my password and other stupid things that I can't do. But really, the rules provide that you need to be up to speed on technology, and if you're not, if you don't have that bent, that's fine, but you need to surround yourself with people who do know how to do it. And let's face it, you're required now, I think, aren't we in the States? Everyone has to have an email address. Everyone has to be able to file electronically. So we're not going to have much of a sense of humor for you to say, I didn't know any better, I didn't know how to balance my trust account, or gosh, I didn't take any steps to avoid all of my files to be poached and held hostage by someone. It's going to happen, and I say this, it's somewhat tongue-in-cheek, but you have to know that I assume that the Chinese and North Koreans have all of your files. We just assume that, okay? I don't care, because they don't care. If it comes to this, and it very well may someday, that people are going to start taking our firm stuff like they are with hospitals and doing the ransom stuff, it may be coming. I don't mean for this to make you stay awake all night, but you need to take reasonable steps to protect yourselves. So be aware of that rule. We are hoping, with where I see my office going, that we keep more up to speed on what you guys are doing. You guys are moving from in-house or government positions to the private practice, that we will provide, in conjunction with the Bar Association, training to help you get on your feet. If You've been in government practice, you don't know the first thing about opening and handling a trust account. We want to be able to provide that between the Bar Association and us. So we're not prosecuting you for silly mistakes. We're helping you avoid mistakes, and we then don't have to prosecute you, and guess what? The public's thrilled with that. And I know my court is on board because they're not out for me to see how many pelts I can bring in every year. They want to see no discipline in the future. And that's just part of the model rule comment. You can't plead ignorance about technology, and you just need to bring yourself up to speed or surround yourself with good people. If you lack the necessary competence, you need to associate yourself with someone who did. I just talked about that, and that appears to be part of the advertising part that it's a little out of place, but basically saying you can't mislead the public on blogs about cases, telling people how great you are with all the good results, because it's misleading to the public. More, yeah, that's the same. These are some links we'll be happy to share. I think Elisa will provide these slides to you if you want them. In terms of the social media side of it, I think we're coming to a close. And so we're just to wrap up with some things, just generally some cases we talked about, spoliation. Just in general, in dealing with my office, some words of wisdom that I have to tell you, true confessions. I responded to those complaints, and if you're not getting a complaint and you're practicing in the area of criminal defense, then I suggest you're not trying very hard on behalf of your clients, because they're going to be upset. But just a few things to keep in mind, and maybe now would be a time for you to think if you have any questions that you could send off to Joel while we're just going through some of these more rules of thumb. Probably the most important is to be honest, and Mama told me never to ruin an apology with an excuse. If you really did mess up, then own it and just tell me the truth, especially if it's a 9C informal investigation. It's not that serious to begin with. It's just something that I need an explanation to tell the complainant, look, this is what she said. And, unless she proves that you're lying to me, which that's be violating number 1 rule, I'm going to dismiss that complaint against you. So it's just going to go away. I give people all the time they want. I just got a pretty serious reply to a response by an attorney that alleges not only lying, but alleges a crime had been committed. And the attorney for that responded and asked for more time, and I gave him my email, basically, take all the time you need. We don't have limitations of actions with few exceptions in my office. I'll give you all the time you need. The worst thing you can do, though, is crawl under a rock and hide, because that only makes it worse. Only on more formal charges, and honestly, let's be frank, you're going to know how serious it is when you get that letter. If it's a formal, for sure, which you're going to receive via certified mail, I'd strongly consider you to have you consider retaining an attorney, or by all means consult with your partners. If you're a solo, at least seek counsel of a friend. And then just try to answer it all in one, especially in an informal. I can't stress enough that if you just answer the questions, give me any good and decent reason why I should dismiss it, I will. And just be as detailed, and I provide this advice too. It served me well when I was on the receiving end of complaints. Detailed time, as in a billing statement, is your best friend. And those of you that do flat fees, criminal cases, I still suggest you keep your time to defend yourself, especially defend yourself with my office. If it's a fee dispute, number 1, shame on you for even getting in that situation, because you'll see those coming a mile away. Make your peace with the person. And you should know this. This will hopefully make you keep your eye on the ball. If you fail to resolve a fee dispute, and they file a complaint with my office, you're not eligible to suggest fee arbitration with the Bar Association. Propose that if you can't resolve it yourself. Please do propose fee arb. All right, Sidekick, do we have a question?
Yep, here's a question. I find it annoying and unethical when a firm advertises for an associate without indicating who they are.
Oh, in the bar, to say firm looking for a young associate and then just send it to a P.O. box?
Correct.
Well, we've discussed that when we've done it in the past. What is the real reason for that, Joel? Is it to protect both? You don't want to air out who's looking. But what I guess I'd like to know, the follow-up from the questioner would be what is the potential ethical pitfall of not requiring or of requiring them to identify themselves?
Just sounds, I guess I've seen it a bunch of different ways. I guess maybe there's a reason why a firm wants to not advertise that they're looking or actively, but I guess I don't see it being unethical, and you're here to tell me whether it is. But I think I understand the frustration. I got another question here. I want to let you know that in immigration court, individuals have used my name as their attorney falsely, and this happens on a regular basis.
I would strongly encourage you to reach out to me. It would be in confidence, because what's going on out there, and it's not in my office, but it's the UPL side next door, that people are not appearing in court but having legal assistants, non-lawyers, basically practicing law, which obviously that's a no-no. But, I don't think I've talked about this before, but I do have many, many files in my office with most of your names on them that are in the miscellaneous category, because it's really not an ethical violation, but I keep track of those to see if there is some common denominator, whether it be the complainant or the attorney involved. So please reach out to my office in total confidence. We will help you out, because I'd like to know that. We would probably refer that over to UPL for prosecution, and you could be a key witness. Maybe you don't want to be, but it's hard to catch these people. Very hard, because our immigrants may have been deported. We'll never have them as a witness. If they're not deported, they're very reluctant to get involved in the legal process that they're wary of to begin with. So please reach out to me.
Another question. Do I have to terminate my social media accounts with my friends or family if they're listed as potential jurors for my case?
Well, I would say a quick answer, being in that situation. I was in a 4-week quadruple homicide trial, and witness number one was my brother. Witness number one, juror number one was my brother. We didn't even know about it. I would say don't fret. Disclose. Those people would never serve on that jury anyway. As I said about my own brother, I was a criminal defense attorney. He is a probation officer. At a sidebar, I said, Judge, I know he can't be fair. You may feel the same way about your friends or family members.
I've got another question. It has to do with legal blogs. Any last-minute advice on attorneys wanting to start one? I think this question kind of comes from a lot of the advertising people, third parties that market to lawyers, say you got to have a blog, right, Mark? So what do you give in, and if you do, what do you want to think of when you're starting?
Well, I think you want to think about disclaimers more than anything. It doesn't create an attorney-client relationship. Every case is different. I think I probably would be critical if I were out in private practice if you're not doing some of those things, like the one at the Mass Tort Conference where the person has got a green screen in the office and shooting little YouTube videos about matters of interest. You got to compete. I get that, and I'm not going to fault you for making a mistake that is an honest mistake. But I think it's just the same old adage your mama told you: tell the truth, be honest, and I'm going to be there to help you. You want to run it by me? I'm glad to listen. So
and just the standard disclaimers that just the mere fact of you reading my legal blog does not create an attorney-client relationship until we have a written agreement to that effect. Right?
Yeah, I think just bold letters that you just are providing this as a service, and yeah, you might get some business out of it. That would be a good thing. Wow, we didn't even get through, I don't know, Joel, we probably had a few more slides to go, but time flew when you're having fun. You guys, thank you for your questions. That was helpful. I would have found myself repeating myself with old slides otherwise, but with that, I think we'll wrap. Joel, thank you for being here with me. Guys behind the scenes at the Nebraska State Bar Association, keep up the good work, and we will see you all soon.
We'll make sure we get this slide presentation to the Bar Association for distribution, and if you want it, please reach out, and we'll make sure you get it. So thanks, everybody, and get one more credit hour to your requirement, and have a great day, and thank you very much.
Let's be ethical out there.